Good morning, everyone, and thank you so much for joining us. I'm Kendra Simmons. I am a shareholder in Frederickson's Des Moines office, and I am thrilled to have my partners, Ann Radolinsky and Pam Abate-Datillo from Minneapolis presenting with me this morning. Pam and I are both employment advisors and litigators, though I think we do more litigation than advice, and Ann is one of our advice experts, I will say, and one of our self-proclaimed recovering litigators as well. But we are thrilled that you have joined us this morning for a discussion of return to work issues. Just a couple of housekeeping items here before we get started. Before we dive into the content today, at the bottom of your screen, you'll see a toolbar with a variety of engagement tools. These tools are resizable and movable, so feel free to move them around to get the most out of your desktop space. If you have any questions during the webcast today, you can submit them through the Q&A tool. We're going to spend the last 30 minutes of our session from about 9:30 to 10 o'clock on Q&A that will be dedicated to that. So please submit your questions throughout as they come up, and we'll cover them at the end of the presentation. Under the Resources tab, you'll find a copy of today's slides and links to our website and the COVID-19 Question of the Day webpage. Live webcast attendees will receive a follow-up email after the webcast with continuing education details. If you are interested in a certificate of attendance, you can download one from the continuing education tool. We're recording today's program, and you'll receive a notification email when the on-demand version becomes available. If you run into any technical difficulties today, try refreshing your screen by hitting F5. You can also click the Help tool for answers to common questions. I would also be remiss if I did not wish my fellow baseball fans out there a happy opening day, especially if you root for the Royals like I do. I'm getting my first vaccine dose this afternoon and looking forward to hopefully heading to the K later this spring or summer for a game. So we're definitely in a different place in the pandemic right now than we were a year ago, and I think we're all excited to be talking about these return to work issues. As for our agenda today, we are going to start with return to work developments. I'll talk about some trends that we're seeing, as well as options for remote versus in-person workspaces and the increasingly hybrid remote option that we're seeing employers take advantage of. Pam will then cover other vaccine and health and safety issues. And finally, Ann will address reasonable accommodation considerations and strategies. And then, like I mentioned earlier, we will spend our last 30 minutes or so on Q&A. So with that, let's jump right into return to work strategies and trends. I thought it would be helpful to start with a snapshot really of kind of where we're at now, and hopefully the figures on here show up clear enough that you can see the statistics. But obviously we all know now that converting to remote work was one of the most common reactions to the pandemic. It was just a little over a year ago that a lot of employers switched either completely or to some degree to remote work. In this slide, it's a survey from salary.com, and it indicates that over 92% of employers at some point had folks working remotely. And quite frankly, I'm surprised that that figure isn't even higher. But to put some additional context around it, 45% of organizations reported having 80% or more of their employees working from home. So that shows just how drastically I think the pandemic has shifted our thoughts around remote work. Before it, a lot of employers, I think, viewed remote work with skepticism, and it has changed the way we're going to work, I think, well into the future. And we'll dig into a little bit of how exactly that has changed here in a bit. But we are now, I think, seeing a shift from the focus of the past year or so into a look toward the future and some trends that will impact, I think, folks' ability to attract and retain top talent. The decisions that you're making now regarding remote, in-person, hybrid work, vaccinations, all of these are on the top of employees' minds as well, and will affect the way that everybody views the workplace going forward. But before we can really touch on the options, I wanted to highlight the main sets of rules that govern the decisions that you'll be making regarding remote versus in-person work. And I'll touch briefly here on CDC and OSHA guidance, but quite frankly, I'm sure most of you are quite familiar with these sets of rules at this point, and I've included the links here so that you can go back and view them in more detail later and get the details that way. Pam will also touch on some of the rules in her part of the presentation here in a bit, but I wanted to give you the highlights here. As for the CDC guidance, this image here, the hierarchy of controls, illustrates, I think, really well the utility of the different options you have as employers in structuring your physical workspace. So if you start in the middle there, the yellow box with engineering controls, those are measures like improving ventilation, structuring workplaces or like workstations in a way that folks are distanced and have, maybe plastic shields to protect them from certain airborne particles. We then move to the orange box, administrative controls. And those are the measures you can take, like increased cleaning, disinfecting, alternating schedules to avoid the number of employees in the workplace at any given time and limit exposure that way. And then the last box there, PPE, those are the things like face coverings that are, I don't want to say last resort and mean it that way, but it is, that measure is less preventative and more, protection focused. So that's why it's at the bottom of that hierarchy of controls. So the CDC guidance is certainly, a set of rules that you want to stay up to speed on. OSHA is another set of rules that you want to stay up to date on as well. And so I'd encourage you to check back on these links regularly. But OSHA most recently posted guidance about a week after the start of the Biden administration, and then here recently earlier, well, now that we're in April, it would have been early last month in March. But the OSHA guidance focuses on some of the same measures that the CDC touches on, cleaning, providing a safe and clean workspace, but also emphasizing the importance of face coverings, as well as other of those engineering and administrative controls that you can implement to provide a safe workplace to your employees. It's important to remember, however, that all employers under OSHA have a general duty to provide a workplace free from recognized hazards that are causing or are likely to cause death or serious physical harm. So that is really the baseline, and I think the minimum duty that all employers need to keep in mind, and why it's important to stay up to date on how you can provide that safe workplace free of those kinds of risks to employees. And Pam will touch on this in a little bit, but OSHA's most recent guidance also talks about not distinguishing between vaccinated and non-vaccinated employees, in the sense that that vaccinated employees should still be taking similar safety measures like wearing face coverings and abiding by other health and safety rules. It is also important to stay up to date on rules at a state level. Like I mentioned, I'm in Frederickson's Des Moines office, and the Iowa state guidance has, quite frankly, been pretty limited throughout the pandemic, in the sense that it defers in large part to the CDC and other related guidance and strongly encourages following that. And at a state level, that's important because depending on which state you're in, you could have some level of immunity if you're in substantial compliance with applicable guidance. We have that here in Iowa. It basically establishes a higher bar for folks to make a claim if they believe they contracted COVID-19 by entering your physical space. And this is different from the employment context, so keep that in mind that to the extent COVID-19 could be contracted in the workplace, there could be potential work comp issues, but in other contexts, there could be some level of immunity if you're in substantial compliance with applicable state rules. And I think North Dakota and South Dakota are largely on par with Iowa in the lack of current mandates or, mask rules and that type of thing. And what is the current status in Minnesota and the rules there as far as face coverings and whether folks can be in the physical workplace or not?
Yeah, we still have mask requirements in place in Minnesota, and we follow the we are required to follow the CDC and the Minnesota Department of Health guidelines that are similar to everything that you've been talking about. With respect to immunity, I just wanted to make a fine point there. In Minnesota, we don't currently have any statutes specific to COVID and immunity from civil liability. We rely on worker comp coverage to provide some level of not immunity, but protection for employers from, very, very potentially large judgments otherwise. There is a bill, at least one, there are a couple of COVID-related bills that are bouncing around in our legislature. One of them would provide a limited immunity from civil liability for certain healthcare providers and first responders in terms of the care that they provided during the public emergency. The most important development or order to know about in Minnesota right now is Governor Walz's most recent order that was issued on March 12th of 2021. We have been under an order that essentially told businesses that unless you're an essential business, unless you have first responders, et cetera, all workers who can work from home were supposed to work from home. Beginning on April 15, it's still strongly encouraged that folks who can work from home do so. However, employers are going to be able to bring people back to the office. It's important, however, along the lines of Kendra's comments, to understand, however, that social distancing, mask requirements, and other CDC and Minnesota Department of Health requirements will still be in place. And importantly, in Minnesota, employers are required to have a preparedness plan. Part of this preparedness plan is so that employers notify employees of the safety protocols and procedures that are going to be in place to protect the health and safety of the employees. A template is available on the Minnesota Department of Health website, and it's pretty decent. The order requires that the preparedness plan be issued to employees, that they be trained on it, that there be a designated individual responsible for overseeing the plan. The executive order that Walz issued also is explicit that employers need to be aware of and continue to be in conformance with federal and state human rights laws to provide reasonable accommodation to folks with disabilities. And the other thing to think about in Minnesota with these executive orders, and particularly the most recent one, is that violations can result in fines and penalties, and they are not insubstantial.
Thanks for that, Anne. And I know that Pam is going to touch on those preparedness plans that are required in Minnesota as well here in a bit. But with that guidance and those rules in mind, let's talk now about the options for structuring your workplace going forward. Should you be fully remote? Should you be fully in person? Or some combination thereof? And as far as that last hybrid option goes, there are different ways to make your workplace a hybrid workplace. You can structure that by position, meaning that you could have some employees completely remote and other employees or other positions fully in the office. You could also make your workplace hybrid by alternating schedules. So you could have one group of employees that's in the office, let's say Monday, Wednesday, Friday, and another group of employees that's in there Tuesday, Thursday, something like that. So we will dig into each of these options in more detail as we go through the slides here, but wanted to emphasize that this is really, as you are exploring and considering these options going forward, this is really your chance as an employer to re-emphasize your culture and re-emphasize that going forward, and the decisions you make in this context are going to really communicate your approach and your philosophies and your values going forward. So look at this really as an opportunity to define your workspace for well into the future. First, as it relates to remote work, to the extent you are either fully remote or partially remote, I wanted to emphasize the importance of documenting how that is going. This will help you not only assess how it is going and make decisions about how much you want your workplace to be remote in the future, but it also helps you make those decisions and gives you support for whatever decisions you make so that you can communicate those decisions to your employees. As just one example, I was dialed into a couple weeks ago a virtual conference where a representative from the EEOC spoke, and she touched on the increase in claims that the EEOC is seeing related to decisions of employers in bringing folks either back to work or keeping them remote. And she gave one example where there was an entire unit of one employer that was brought back to the office except for one employee, and that one employee was female. And her mind naturally jumped to, well, I'm the only female still working remote. All others have been brought back to the workplace. What other reason could there be for that decision than my gender? So if you don't assess and document these things, it's really, employees will fill in the blank with something that is probably not accurate, but also not helpful. And so you can really get out in front of those issues by documenting the reasons for your remote work decisions. And also, to the extent that issues arise, you can then point to those if, let's say, performance issues come up with employees who are working remotely. You don't want to wait until folks return to the workplace to assess those performance issues. If there are problems with your remote work setup or an employee in particular, you need to nip that in the bud, so to speak, and document that so that that can help you make decisions about who is working remotely and the extent to which your workforce can either remain remote into the future or have an option to work remotely once you've opened up to some extent. And then, like I said, communicate these decisions to your employees. Not only what the decision is, but to the extent that you are remaining remote for any portion of time. If you expect that to change at any point in the future, it's important, I think, to communicate that to employees now. We've been telling clients for, the past year to emphasize to employees that remote work setups have been in large part out of necessity, right, due to health and safety issues. But it's not going to necessarily be that way going forward. And if employees know that, and expect that as they continue to work remotely. It makes it easier once you eventually make a decision about returning some of those employees to the physical workspace. It doesn't come as a surprise. We're seeing a lot of clients now run into issues where employees are questioning, well, I've been doing my job remotely for a year. It's worked. I can be productive. Why not continue doing that, right? And so if you can, again, get out in front of that and communicate to employees appropriately, that'll go a long way to helping you implement any return to work decisions you make down the road. To the extent that you have not already, you also want to put policies and measures in place to protect your confidential information. These are things like security measures that include a virtual private network, challenging passwords, multi-factor authentication. There have been plenty of stories in the news of businesses of all kinds getting hacked over the past year, with hackers knowing that people are working remotely and, folks can be easy targets. So you want to do everything you can to not make yourself an easy target. You can also limit access to certain programs or data when people are working remotely, and monitor and track what employees download or send outside of the network. If they have the ability to plug in things like USB devices to their laptops or computers, you want the ability to track that. I've had a couple non-compete cases recently where you just would not believe what employees are doing with information, and perhaps thinking that employers don't have the ability to track that. So make sure that that is part of what you have the ability to track. You also want to have either some kind of telework or remote work policy or agreements in place with individual employees about what the expectations are around remote work. And then finally, consider employee reactions and feelings around remote work. I'll get into some statistics here in a bit, but the feelings really vary and run the gamut from people who love remote work and want to do it, completely into the future. Others who, would rather go into the office every single day, and then you have a large group of folks in the middle. There's been a survey where more than half of U.S. workers say that they would choose to permanently work from home on a full-time basis if given the option. And within that group, 45% said that they would accept up to a 5% reduction in salary to work from home on a full-time basis, and 8% would accept up to a 20% reduction or more in salary. So a long way of saying that I think now that the pandemic has shifted our attitudes around remote work, employees are going to be looking for at least some kind of flexibility. Even if you're not working remotely completely, they're going to be looking for some kind of option or flexibility in that regard. And they may be willing to take a pay cut for that flexibility. So to the extent that you are not accommodating that, or at least exploring those options, you could be putting yourself at risk of losing top talent. And as I transition into talking about in-person work here, I'll just give one example of going back to that same virtual conference I mentioned earlier. In-house counsel at Google also spoke at that conference, and she touched on how they are giving employees, with the exception of some positions that really make sense to have on site due to, the capabilities that they need, network access, that kind of thing. They're really leaving it open to employee choice, whether they work remotely or come on site. And I'm not necessarily advocating for that approach in whole, but I wanted to cite it as an example that if Google, which I think is pretty universally known for its company culture, can explore adjusting in that way, I think many companies will be challenged to do the same. So talking more about in-person work, the first item you want to tackle is who you are going to bring back to the workplace. And by that, I mean, which positions specifically, which positions make sense to have in the office. Again, whether it's due to network access or just facilities, machines, and obviously there are some, industries where remote work really isn't a possibility at all. But you want to think position by position about who you are going to bring back. And again, document that plan and communicate it, because to the extent that you end up facing a charge or even just some kind of informal complaint or challenge from employees, you want to be able to explain your reasoning so that they don't fill in the blank with something that's not favorable. You can also consider reopening in phases or alternating schedules. This builds in some trial periods for you, especially if you haven't been in person in a while. You can try it out, so to speak, and work out the kinks with any safety issues or otherwise that come up. And it gives employees the chance to get used to working in person as well. However, to the extent that you are reopening or having folks in person in the workplace, you want to continue any safety measures and that gets to the rules and the guidance that we talked about earlier. Employees should continue wearing face coverings to the extent that it's required, either under applicable guidance or under Minnesota state law at this point. Social distancing, extra cleaning, all those things. And you need to be prepared to discipline employees who aren't wanting to follow those safety measures. Obviously, you go through a process and explore what any concerns may be and make accommodations if necessary. But at some point, discipline may become necessary if employees aren't willing to follow applicable safety measures. But like I mentioned, offering a remote work option is going to be something that a lot of employees are looking for into the future, just that flexibility. It can foster employee well-being, mental health, etc. The important thing here, I think, is to emphasize that you should be very clear about who is eligible for any remote work option and make very clear the circumstances under which it can be revoked. So is the employee making the decision? Is it up to the employer or the manager or supervisor of the particular employee and when they get to work remotely or when they don't? Is it done by some kind of schedule? You need to be very clear about what the parameters are around that. And again, leave yourself room to revoke the option if for some reason it you find that it's no longer working. And then finally, decide what aspects of remote work you want to keep. I've found that over the past year, we've discovered measures that have really improved efficiency, reducing travel. There may be a lot of meetings that make sense to keep completely virtual instead of having in person. And then I know I'm never going to look at a lunch buffet the same way. I mean, maybe that is something that just gets nixed going forward into the future. But really think about those aspects and what can improve efficiency in your workplace to the extent that you convert to in-person operations. But as I've mentioned multiple times now, some kind of hybrid option is going to be what most employers offer and what most employees are, I think, looking for. And this image from the Stanford Institute for Economic Policy Research, I think is what that stands for. And I've included the link to the report below. But this really illustrates that wide range in views regarding remote work that I touched on earlier. You've got, around 20% or so of employees that never want to work from home ever again after the pandemic. Another 24% or so, I think, that want to work remotely all the time. And then a wide range of views there in the middle from, 1 to 4 days a week. So with that in mind, what should you consider regarding a potential hybrid workplace? This is something, again, I mentioned that most employers, one survey indicates around 80% plan to implement some kind of hybrid work arrangement where workers can come in some days and work remotely on others, or just keep certain categories of employees working remotely on a permanent basis. And the same survey from Stanford that I mentioned has arrived at the conclusion that working from home anywhere from 1 to 3 days a week is really ideal. So take that for what you will, and implement what's right for your workplace. But I think that it's just another illustration of how important flexibility is going to be going into the future. And 55% of employees want some kind of hybrid environment, according to the same study. So that, I think, should really encourage you to the extent possible to explore what best fits your workplace as far as a potential hybrid environment. And again, this can be structured in different ways, by different positions, by alternating schedules, but you need to clearly define who's eligible, and emphasize that it's a privilege and not an entitlement. Again, we've seen a lot of clients encountering employee situations where it's starting to feel like more of a benefit, I think, instead of a safety issue, having a remote work option. And so it's important to control expectations around that and set your workplace up appropriately. And before I get into my last slide here and some other employee retention and benefits issues, Anne and Pam, have you seen any interesting hybrid options as far as workplaces go with your clients?
Well, Kendra, with my clients, I would say the prevailing view right now is that they are going to go with a hybrid approach. Everyone's looking right now for benchmarks. They want to know what everybody else is doing, what's the norm. And unfortunately, it's too early to have benchmarks. We know that Facebook and Twitter have decided to go complete remote. Google, last I read, is requiring people to come in 3 days a week and live within commuting distance. And those are the first real big companies to announce what they're doing. But here in Minnesota, we just don't have benchmarks yet. But based on my conversations with clients, it just seems like the prevailing view is, as you just said, the 1 to 3 days a week. My recommendation is typically to do it as a temporary plan. So not to commit to it forever or full time, but to put a 3-month cap on it. This is what we're trying for 3 months. And really the driving reason is it's what employees want. It's the best way to ensure you retain top talent. And it's also the best way to ensure you retain a diverse workforce. If it's important to your organization to have a diverse workforce, then I think you need to acknowledge that there was some people call a mass exodus of women from the workforce during the pandemic. It was a temporary exodus to deal with distance learning and family responsibilities. But these women are going to be looking to re-enter the workforce probably this fall, and they're going to be looking for at least a hybrid approach. Now, that's not everyone. I'm speaking in generalities, but there's been much research done and much literature out there on the fact that there were an incredible amount of women who left the workforce. And if we want to retain a diverse workforce, then we have to provide a hybrid approach. Finally, I have a couple clients who have very large spaces, more like campuses. And they're finding now that they don't need all that space and that a private office isn't what employees want. And so if we want to get employees back to the office at least a couple days a week, then we need to reimagine our space, because people aren't coming back to the office to get a private office with a door and a key. If they come back to the office, it's because we have state-of-the-art technology. It's because we have unique collaboration spaces, collaboration rooms. We have technology rooms for doing the kind of thing we're doing today, doing webinars and putting on presentations, meeting with clients. That's the type of thing that's going to draw employees back to the office. So I do have a couple clients who are looking at how can we completely reimagine our physical space to convert private office space to spaces that are going to have the best technology that's out there and that will be a draw for employees to come back to the office. Anne, I don't know if you have anything to add as well.
You covered it beautifully, Pam. I won't repeat what Pam said. I agree with all of her points. The only thing I would say, a couple of points. One is that, of course, we're talking about outside of the healthcare industry and some of the manufacturing operations. I have a wide range of clients in many industries. So there's certain clients that aren't looking for a hybrid approach for the most part. But I think that going into 2021 and beyond, employees and employers alike are looking for flexibility, both in terms of whether they're at the office or working elsewhere and otherwise. I did want to just throw out one idea on this compensation piece, however, and perhaps a point of caution, especially for employers that have affirmative action obligations, but even beyond that, and it's a pay equity concept. So I would caution employers that if they are considering adjusting compensation down because someone is working remotely, there really should be some very legitimate reasons for doing that. I am not really coming up with any off the top of my head. And if you are an affirmative action employer, you certainly should check with counsel before you do that, and also just with other questions about your compensation system. And also, if you are on either of the coasts, if you have operations on either of the coasts, there are very, very progressive pay equity laws that could cause some difficulties. And those laws are percolating up in other states. And I imagine as our new administration settles in, they're going to percolate up some more.
Thank you both. And Anne, that's actually a perfect segue into my last bit, which is about other considerations, I think, for attracting and retaining top talent. Spinning off of Anne's point, now would be a natural point to reassess your compensation structure to focus on attracting and retaining top talent, and also consider the option or possibility that to the extent any of your employees convert to full-time remote work, and perhaps even relocate, consider what that means for your business as far as not only compensation, but making sure that those wages are taxed appropriately depending on the employee's location, and if necessary, that you adjust your business registrations accordingly. And I'll throw out one example from salary.com presentation that I had tuned into. They had a client based in San Francisco that had employees convert to full-time remote work and relocate to some location that is much less expensive than San Francisco. And accordingly, that company looked at restructuring or decreasing those employees' compensation, which was based in part on the expense of living in San Francisco. So wanted to raise that for consideration and plant the seed that you should be thinking about what you would do in those situations if employees decide to relocate if they're working remotely on a permanent basis. And then finally, now is a perfect time to be reassessing what you can do from a benefits perspective as well. Going back to the key around flexibility, now is a natural time to look at restructuring your PTO and other leave. Now that the FFCRA has been extended on a voluntary basis for covered employers who choose to offer it through September, but what other, paid leave could you consider offering to provide employees the flexibility that they may be looking for? And then really push for the benefits that are going to improve your employees' well-being going forward. If you can advocate for continued support for telehealth and other mental health programs, that is, I think, a big lesson and issue that has come out of the pandemic as well. But use this really as an opportunity to reset and think about what you can provide from a benefits perspective that's going to incentivize your employees going forward. With that, I will toss it to Pam to cover vaccine and other safety and health initiatives.
Thanks, Kendra. And Kendra made so many great points this morning, and I just want to pick up on one thing and maybe emphasize it and give a little more context for it. But one of the things Kendra mentioned was that if remote work is going to continue in any form or fashion at your company, I would highly recommend you be extremely vigilant going forward about cybersecurity attacks. So Kendra mentioned that there's been an enormous increase in cybersecurity attacks since the pandemic began. And what experts are saying is that it's because of all of the remote work, security measures have gone far down. And I've seen statistics that show only 5% of company files are adequately protected. And when we talk about hackers, I heard an FBI agent speak about this a few months ago, and the way they put it really stuck with me. So this is not the 19-year-old kid living in his mom's basement hacking your company's files. These are sophisticated international criminal organizations that are taking an entire a company's entire data. They study you for months, typically get in through a phishing email. So one employee inadvertently clicks on a phishing email. That's how they get access. They study your systems for months or weeks, and then they launch a massive attack that holds all of your data hostage, and then they demand millions of dollars for that data to be released back to the company. And this is not just something happening to, big Fortune 100 companies. I had 3 clients in 1 month in Minnesota, 2 of them small family-owned businesses who got hit with the exact same scheme they believe was, that the law enforcement that they spoke to believe was run by a Russian criminal organization. So this is serious stuff. And unfortunately, companies are learning about it only the hard way once they go through it. Then, of course, you come out of it much better if you survive it. You come out better with a better understanding of what steps you need to take to improve security. But of course, we don't want it to get to that point. Nobody wants it to get to that point. So if remote work is going to continue, and even if it's not, it's still a good idea to reevaluate your cybersecurity systems. Your director of IT, if you have one, would, I'm sure, love to have the opportunity to engage an outside consultant who is an expert at evaluating these systems and pointing out for you, doing an audit, telling you where you're weak, and giving you ideas for products or solutions that can improve security. So anyway, just wanted to add that because you hear about these big cybersecurity attacks in the news, and the ones that get reported are the big companies. And I'm seeing it happen to small family-owned businesses here in Minnesota. All right, so now vaccines and other safety initiatives. I have a couple topics I'm going to cover before I get to vaccines. And I'm going to do that rather quickly because really the heart of this part of the presentation is talking about vaccine initiatives. And I want to share my research and my insight with you. And I also want to make sure that Kendra and Ann have an opportunity to share their insight as well. So if it feels like I'm flipping through these first few slides very quickly, that's on purpose because we want to get to the vaccine part, and the slides are designed in a way that you can go back and click on the links and get virtually all of the information that's in the slides through the links. All right, so first thing, this is hopefully a reminder to everybody listening to the webinar today, and hopefully this isn't new information, but if it is new information, it's okay. It's never too late to get yourself on the right track and get caught up with the governor's orders. In the state of Minnesota, every company must have a written COVID-19 preparedness plan. They must. This isn't just if you're returning employees to work on April 15th. It's not only if you closed and then you're reopening. It's not for essential versus non-essential or vice versa. Every company, period. So every single company that is listening to this webinar today should already have a written COVID-19 preparedness plan. If you don't, I would make that a priority this week to get that done, because we are going to see increased enforcement actions here, I think, in this next year. So put anything that's in red, there's a hyperlink there. You can go and click directly on the executive order and verify that what I've told you is accurate, that every single business must have a COVID-19 preparedness plan before there are any employees who work in person. Even if it's not required in your state, and Kendra, maybe you can comment on this. It sounds like it's not required in Iowa, is that right?
That is correct. I mean, I think some of the OSHA guidance talks about having certain prevention plans, et cetera, in place, but Iowa does not require the kind of written preparedness plan that Minnesota does. But I think as a best practice, employers, should consider some kind of policy or guidance or communication to employees about what they're doing, but it is not required.
And the reason why Kendra and I are in agreement here that even if your state doesn't require one, you should have one, is that this can be your best defense if you're sued. If you're sued by an employee, if you're sued by a third party, either for a transmission of COVID in the workplace or a whistleblower retaliation claim, if you have a written plan and if you are following that written plan, that can be your best defense to what is often a dispute over what was going on in the workplace and whether adequate measures were being taken to prevent the transmission of COVID. If you have one already, which I hope most of you do, now would be a good time to refresh. If you're working on a plan at the moment that's going to bring more people back to the office, you need to pull out that COVID preparedness plan and make sure it contemplates this increased return to work, because most of my clients did these plans back when they only had maybe 10% of their employees or 15% working in the office. And so the considerations were different. So it's time to refresh if you have one and you're planning to bring more employees back to the office. So hopefully this is also familiar to you. You don't need to start from scratch. There are templates that are available from the Department of Health. Sometimes we don't like the government templates because they go way further than the law requires you to go, so we don't like them as lawyers. These are actually pretty good. There's a couple places that caught me off guard when I was working with clients on putting these in place that I thought went beyond what they needed to do under the law, so we scaled those pieces back. But for the most part, it's a great plan, and if you don't have one, it's a good starting point. The other thing I want to point out is that a lot of clients implemented these back in May, or a lot of employers implement these, in May, the late spring. Since then, the Department of Labor and Industry has come out with industry-specific plans. So again, it's time for a refresh, if you haven't done a refresh in a while, to make sure you're using, first of all, the latest and greatest templates that the department has provided, and to make sure that if you are one of the industries that has to have a specific plan, that you've implemented the components of that specific plan. Because those industry-specific plans include things that the general template doesn't include, that deal with customers, vendors, and other similar issues. All right, so this is the part I'm going to fly through quickly because this is all in the templates, and if you're using the templates, you've got this covered. But generally, requirements are you have to have someone at your company who is the plan administrator, the person who basically owns the plan. The plan has to be on site and easily accessible, and you have to ensure that every activity in your building follows the protocol. So it's not enough to have the plan, you have to actually follow it. Again, quickly here, there are rules within the plan about how you identify sick workers and ensure that they stay home, protocols for social distancing, wearing face coverings, hygiene. You need to address building and ventilation protocols in the plan so that employees are aware of what the building and ventilation protocols are at your office, and you have to address cleaning. And importantly, everyone has to be trained on the policy. So perhaps you did a training back when you first implemented the plan. Now would be a really great time as you're bringing more employees back to work to do a refresh on training, to update the plan, and do a brand new training. So, in summary here, you have to have the plan, you have to enforce it, you have to follow it. Why? Because it's required by the executive order. The executive orders have the same effect as any other law that is passed. It is binding on companies, they have to follow it. Employees do not have a private cause of action. If you fail to follow the executive order, employees can't file a private lawsuit. But as Ann pointed out, the government can file a lawsuit against you or conduct an investigation and can issue fines. Some businesses have been fined $25,000 per occurrence for violating the executive order. But there's other reasons to follow your plan beyond just it's required by the executive order. And I touched on this a little bit in terms of minimizing your exposure. Now, if an employee contracts COVID in the workplace, most likely the employee's remedies are going to be limited to workers' compensation. So employers will often ask us, if an employee gets COVID, can they sue us? And the answer to that question is yes, but only for workers' compensation. Some employees have attempted to get around the workers' compensation system because workers' compensation has caps on how much they can recover. And of course, filing a lawsuit in court can get much more significant damages. So some employees have tried to get around the workers' compensation system by pointing to things like systematic, consistent failures, refusals by the employer to follow executive orders, laws, CDC guidance, OSHA guidance. For the most part, those lawsuits have been unsuccessful. However, they are a PR problem. Walmart went through a few of these when an employee contracted COVID and a couple employees contracted COVID and died. And the family sued Walmart alleging that they were totally reckless in allowing the transmission of COVID by not following certain laws and guidance. So even if you're successful in limiting an employee to workers' compensation, it's a PR problem and it's likely going to result in a investigation by a department agency. Right now, and I'll get to this in a minute, but OSHA is increasing enforcement this year. They have been given millions of dollars to now investigate and cite employers for failing to follow OSHA guidance. And they've said that the way they're going to prioritize who they investigate includes who has a complaint against them. So if an employee makes a complaint, a whistleblower complaint or another complaint to OSHA, that may increase the likelihood that you get then an OSHA investigation. All right, so next topic, and this will be the last topic before we get to vaccine policies. Masks in the workplace. As Ann mentioned earlier, we in Minnesota are still under a mask mandate, a statewide executive order that requires people to wear masks, including at work, unless they are in a conference room by themselves or in their office and they have walls up past their face. There's been a lot of confusion recently because the CDC came out and said that if fully vaccinated individuals are gathered together indoors with other fully vaccinated individuals, then they do not have to wear face coverings. So I've had several clients ask whether that means they can now allow their vaccinated employees to meet at work in a conference room and they don't have to wear masks because everyone is vaccinated. The answer to that is no, even though that would be consistent with the CDC guidance. CDC guidance is guidance. The executive order in Minnesota has the full force and effect of a law. It is binding on all employers, and it takes precedence over the CDC guidance. So at this moment, the answer is no. All employees still need to wear face coverings at work unless they fall into one of the exceptions I mentioned about being in a conference room or being in a private office. Also, OSHA, right now it's a recommendation, but I think that's going to be changing quickly, and it's going to be turning into a purported requirement. But at this moment, OSHA says as well that masks must be worn, or should be worn, excuse me, at work. In our executive order in Minnesota indicates that employers should follow OSHA guidance. So face coverings still binding in Minnesota, can't have any different rules for people who are fully vaccinated. So a couple more comments on OSHA enforcement. One of the very first executive orders that President Biden signed when he took office in January 2021 was an executive order on protecting worker health and safety. And it does a couple of things. First, it directs OSHA to increase enforcement of existing agency standards. In preparing for this presentation, I was asking Kendra and Ann whether they've seen a lot of OSHA investigations over workplace safety, hygiene, mask wearing, and we all concurred that we really hadn't in the last year. I've dealt with a few whistleblower complaints, employees making a complaint to OSHA, claiming that they were retaliated against for having complained about the employer not following, for example, the mask mandate. But we really haven't seen a lot of OSHA investigations focused on these issues. That is going to change in 2021. And when you get to the next slide, you'll see the money that's been allocated for this. It's not simply a proclamation that we are going to increase enforcement. There's real dollars that have been put behind this. So there are people whose jobs are now to go out and do just these investigations. The other thing President Biden's executive order directed OSHA to do was to consider whether any emergency standards related to COVID are necessary, especially regarding masks. And without getting too far into the weeds on this, essentially what this is saying is that OSHA has guidance that recommends the use of masks, but the Biden administration is directing OSHA to consider whether it should issue a rule, an emergency rule, basically requiring masks. And that would potentially apply nationwide and would supersede the states like Kendra's Iowa that do not require masks in the workplace. Now, I say things like purported and would potentially because there would immediately be a lawsuit and there would immediately probably be an injunction somewhere, somehow. So it would take a while to determine whether or not OSHA actually has that authority, but that is what is in the works. Now, President Biden gave a deadline of, it was March 15th. We're past the deadline. The emergency standards haven't come out, but it is being reported that they have been drafted. They have been sent to the Biden administration for review. So we're expecting to see those really any day now. So the money, this slide is all about the money. $100 million has been allocated to OSHA. $10 million is for training and $5 million is for enforcement activities. So as I mentioned, there are real dollars being put behind the enforcement piece. On March 12th, OSHA issued a new national emphasis program, and that is a program for enforcement. And they are targeting specific industries as well as businesses that have had complaints against them or have had deaths or serious illnesses from COVID that were contracted in the workplace. And then this emergency temporary standard is forthcoming. And that's the piece that talks about, it's not just about masks, but that's the thing that seems to be on most people's minds, especially in states that don't have mask mandates. But the emergency temporary standard will address other workplace safety issues, not just face coverings. So the NEP, that's the National Emphasis Program I just mentioned, is targeting these industries. And I won't read them out loud. You can go back and look at the slides if you're interested, but they've identified the specific industries that they will be targeting first for investigations, and then also including those other categories I mentioned of employers that have complaints or employers that have had, there's been serious COVID cases from the workplace. All right, so now we're turning to vaccine policies, and this is really, seems to be the question of the week. What should employers do about vaccines? And so the primary things I'm planning to cover with some input from Ann and Kendra is, first of all, can employers require vaccines? Should they require vaccines? And if they choose not to, can they enact and should they enact policies that differentiate between those that are fully vaccinated and those that are not? So that's at a high level what we're planning to cover. So employer options when it comes to the COVID-19 vaccine are, number one, employers can require vaccination. That's true even for non-healthcare employers. So prior to COVID, there actually has been some litigation over vaccine requirements. And virtually all of those vaccine requirement cases deal with the flu vaccine. And some healthcare employers have been requiring the flu vaccine for employees for quite some time. So the concept of requiring a vaccine isn't novel. What's novel in terms of what's happening right now is that employers outside of healthcare, for really the first time, are very interested in the possibility of requiring vaccines. Most of the prior case law and the prior litigation up to 2020 really was in the healthcare context. However, that body of case law gives us a good indication of what basically the rules of the road would be from an employment perspective with respect to the COVID vaccine. So as a starting point, private employers can choose to require the vaccine. You don't have to be a healthcare employer to choose that. However, we're going to talk about exemptions and some logistical difficulties of having such a policy, but I just want everyone to understand as a baseline, it is something that is allowed from an employment law perspective. All right, option 2 is encouraging vaccines. A lot of employers have opted to not require the vaccine, but instead to sort of loosely encourage it. Third option is to actually incentivize vaccination, and that's where an employer would actually give something of value to employees who have obtained the vaccine. And then fourth is taking no position and having no policy, letting everyone decide for themselves what they want to do without any encouragement or incentive from the employer. So as a starting point, I think it's important to acknowledge where we're at in terms of vaccination and where we expect to be. So at this time, there are 70 to 80% of people over the age of 65 have received the COVID-19 vaccine. But most of the people that are logged into this webinar this morning, that's probably not the primary group that represents your workforce. Is probably not the 65 and older. So we need to look at age groups beyond that. And so what the data is what the public polls are currently showing is that about half of Americans say they definitely intend to get the vaccine. And then there's this big group you can see on this slide here that is probably going to get it, 17%, but aren't a definite yet. So in order to reach herd immunity, we have to get to 80%. That's what the experts are saying. We get there either through vaccination or through people who have had COVID and have antibodies. So it's important as a benchmark to recognize that while the numbers are trending up of people who are willing to get the vaccine, because these numbers look much different last fall. It was a much lower percentage of people who were definitely committed to getting the vaccine. The numbers are trending up, but if left to voluntary participation, there's a question as to whether or not we will actually get to 80%. All right, those that are either definitely not getting the vaccine or are probably not getting the vaccine have cited these reasons for why they are not. The number one reason would be concern about side effects. People are also concerned the vaccine was developed too quickly. They want to know more about how well they work. They've seen too many mistakes from the medical care system in the past. They don't think they need it. They do not get vaccines in general. So that the group of people who just do not get vaccines is actually very small. Most of these reasons are reasons that reflect why the tide has continued to move in the direction of more people getting the vaccine, because they are largely things that are anchored on education, time that shows the effectiveness and the lack of severe side effects from the vaccine. So requiring vaccines, I already mentioned private employers can require it. However, there are certain exemptions that employers have to consider. First of all, under the Americans with Disabilities Act, if a disabled employee, and remember that disability is defined very broadly under the ADA. So if a disabled employee cannot obtain the vaccine due to a medical condition, then the employer must consider providing a reasonable accommodation. By consider, I mean the employer has to offer a reasonable accommodation unless doing so would be an undue hardship. Second, under Title VII, individuals who have a sincerely held religious belief or religious objection to the vaccine, again, the employer must provide a reasonable accommodation if doing so would not be a hardship. So as a baseline, those are the two big categories of people that there would need to be consideration and discussion about a reasonable accommodation that would allow them to continue working for the company but not obtain the vaccine. A third group is pregnant employees. Minnesota has a state law that requires accommodations for pregnant employees. Under the federal law, its pregnancy might need to be accommodated, but it has to first be a disability. So we don't need to worry about that because in Minnesota, we have to provide accommodations for pregnant employees, and the vaccine has not been fully tested yet on pregnant women. So those are the three main groups that could be entitled to an exemption. So a couple other comments about exemption. I'm going to open up to Ann and Kendra to offer any comments they have on this piece. But with respect to an exemption, I want to point out a couple things. First is that if someone has a sincerely held religious belief or a disability that prevents them from getting the vaccine, that does not mean that they automatically get to continue working for the company and doing everything that everyone else is doing, and they just don't have to get a vaccine. Reasonable accommodations take a lot of different forms. There are some old cases that are healthcare cases that talk about, again, back to this flu vaccine requirement. There are some cases that demonstrate that a reasonable accommodation might not mean you just get to walk around and do what everyone else is doing while being unvaccinated. You can potentially offer the person remote work instead of coming to work as a reasonable accommodation. You could require masks or social distancing or other possible COVID testing. There are other things that could be offered. It really is going to depend on your unique situation, what your need, your business need is for having the COVID vaccine. If your employee who wants the exemption is customer facing, is patient facing. So I can't tell you what the accommodation would be. In some cases, there might not be an accommodation and the person has to be let go because it would be an undue hardship, imposing a safety risk to others. So just know that there's a lot of variety in terms of reasonable accommodations that would come into play, and it's not going to be a one size fits all, but you need to have those exemptions on your radar. So Kendra, Ann, do you have any comments on exemptions, or maybe any tips for how employers deal with things like religious objection, which is obviously not the same as a moral or philosophical or political objection?
Yeah, I'll jump in here and say that a lot of the reasonable accommodations or alternatives, I think to your point, Pam, it's going to depend on the situation and also factors like herd immunity and the level of variant spread and how, much more easily spread or deadly those variants are. That will all impact the direct threat analysis that plays into that reasonable accommodation consideration. And I don't know if either you or Ann can speak to, I know in Minnesota, we were talking previously, Pam, about the conscientious objection consideration, and maybe one of you can speak about that and how that could be an exemption that employers could consider offering.
Sure. So yeah, Kendra and I were doing a presentation yesterday and this came up. And the concept is this: under employment laws, the exemptions that the employers have to give are the ones I just mentioned. But there are a whole different set of laws that deal with school vaccination requirements. So in Minnesota, there is a school vaccination law that requires students who attend school to be vaccinated. And that law has its own set of exemptions. And one of the exemptions allowed under the school vaccination law is for people with a conscientious belief. That's different than a sincerely held religious belief. Sincerely held religious belief is not simply a moral objection or a political objection, which is what a lot of the objections right now are to the vaccine. It has to be a fundamental religious belief. So an example would be if, and this is an if, I'm not commenting on how these particular vaccines were made, but if a vaccine is made using embryonic stem cells, or excuse me, fetal tissue, then an employee may have a sincerely held religious belief that doesn't allow them to obtain a vaccine because it either contains fetal cells or it was produced using fetal cells. Now, let's say that employee is Catholic. The established religion, Catholic Church, has not come out and said that employees should not, or individuals should not obtain the vaccine for religious reasons. They have acknowledged the use of fetal tissue in the certain testing of certain vaccines, too complicated to get into today, but the established religion has not said that all members of the faith should not obtain the vaccine. In fact, they've encouraged it. That doesn't mean that the employee doesn't personally have a sincerely held religious belief. So evaluating these exemption requests is so delicate and difficult because it's what does the person personally believe. It's not about the established religion. So it gets very difficult in determining who qualifies and who doesn't. And so for that reason, some employers are considering, well, if we have a mandatory vaccine policy in the future, maybe we would just adopt a broader exemption, a conscientious belief objection, follow the Minnesota school vaccine law idea, and then we don't have to deal with that. Now, the downside is that more people are going to qualify for the exemption. So if your goal is to get to 80% or whatever you've set as your internal goal, giving a broader exemption is going to not help facilitate that goal, but and in turn would cut out some of the administrative headache and allow more employees to qualify. So I want to move on from requiring vaccines because most employers are not doing that at this time. So we have had many, many questions from clients about should we, and after have had a similar discussion with many companies in Minnesota, and virtually every single one I have talked to, at the end of the conversation or at the end of the analysis that they've done, they've decided not to require. And the reason is that it's unpopular. It's controversial. There's a article written by a law professor that I recently read that showed, or she did some research and pulled some statistics to show that when you require something like a vaccine and it's required on individuals, it often creates more resistance because at the end of the day, we're all Americans and we don't like being told what to do with our physical body and our physical well-being. So the vaccine policies are unpopular. So that's a big reason why employers are not doing it. Employers are also not doing it because they're waiting. They want to see whether we get to herd immunity without having to take any of those measures. Let's try first education, encouragement, incenting, and if depending on what happens with the pandemic in a few months, we can change our mind. We can pivot. We can require vaccines in a few months. There's no reason to do it now This is the thought process of many employers. No reason to do it right now because we can pivot in a few months. Where if we require vaccines now, it's actually hard to pivot the other way in 4 months. So that's why most employers are choosing not to require the vaccine at this time, except certain healthcare companies that have a real urgent need to require it. We're seeing some healthcare companies choose to do that. All right, I want to talk about one more issue as to requirement, and then we're going to talk more generally about encouraging and incentivizing vaccines. One other thing that should be on your radar, maybe your company is a healthcare company, you've already decided that you will require it and you have, good reason to do so. Or maybe you're just contemplating, should we require it? I just want to point out a couple things. First is that, of course, you need to be mindful of the exemptions I already discussed, but you also have to think about adverse impact claims. So under discrimination laws, there's two types of discrimination. One is when one person is singled out and treated differently because of their disability or because of their religious belief, or you deny them an exemption without good reason. You've discriminated against them because they have a right to accommodation. There's an entirely different type of discrimination. And that type of discrimination is called disparate impact. And what it means is an employer has a policy that's facially neutral. So we're going to require vaccines. It's not discriminatory because we're requiring it of everyone. But the impact of the policy has an adverse impact on certain protected groups. So that's another thing to keep in mind and to assess whether or not you're running a risk of a class action lawsuit for a disparate impact. And disability is the most obvious. Disabled employees would be the most obvious group of employees that would be disparately impact. But something that might not be on your radar right now, but should be, is that rates of vaccination vary widely based on race. It's a big problem. It has been reported about widely in both the U.S. and in Minnesota in March. I included links to a couple articles that are not just news articles, but they actually pulled data, vaccination data, to show the difference between whites and non-whites who have obtained the vaccine. So the reason for that is still being researched. Is it an access issue? Is it a personal choice issue? But whatever the reason, your policy could have a disparate impact on racial minorities. And so that should be on your radar. Hopefully that changes now that the vaccine is available to all adults in Minnesota. It's not just available to those older age groups and the people with underlying health conditions. So this problem may work itself out, but it should be on your radar, and you should be thinking about how we address that in terms of facilitating. If it's an access issue, well, as an employer, you can facilitate providing the vaccine or providing means for employees to get it off-site. All right, encouraging vaccines. Most of my clients who I've had this discussion with have opted to either encourage vaccines or incentivize them rather than require them for the reasons that we've already discussed. Encouraging vaccines is typically something as simple as communication from the top leaders of the organization via email or some other form that says we encourage employees to get vaccines, but at this time, we are not going to require it. Another key component of encouragement is education. If you went back to the slide where I showed the reasons that people are objecting to a vaccine, many of those could be addressed through education. So again, that's another way employers can encourage vaccines through more than just an email that says, hey, we encourage you to get it. Providing educational opportunities for employees would be another idea. Going a step further than encouraging is incenting vaccines. So the most common ways employers are incenting employees to get the vaccine is through offering PTO days, offering a cash bonus, and asking employees to basically self-report when they obtain the vaccine so that they are eligible for the incentive. So Kendra, Ann, wondering, first of all, what are you seeing your clients do between the three options we've discussed, requiring, encouraging, incenting? And if you're seeing the latter, what types of incentives are you seeing employers offer?
Most of my clients, well, first of all, like you, Pam, none of my clients that I've talked to on this issue are requiring it. Most are taking the approach of encouraging, promoting, educating employees on the vaccine. I haven't talked to any who are choosing to incentivize vaccination at this time, but the PTO and the cash payment offers are ones that I've seen reported in the news, some of the larger employers throughout the country. The consideration I would throw out on those incentives is consider what you are going to do for employees. If you offer those incentives, think about what alternative you're going to offer for the employees who would be entitled to a religious or a disability exemption. If they can't get the vaccine for those reasons, but you're offering the incentive, you should consider offering some kind of alternative, like if those employees go through some kind of education program or seminar, then they can receive whatever incentive it is that you're offering, so that you don't encounter that kind of disparate impact claim that you were just talking about, Pam.
And how about you, Ann?
Yeah, my clients similarly are not deciding in the end not to require the vaccine after having a discussion of many of the issues that you've covered. The only exception so far that I've seen is a company that manages long-term care facilities. And even they are talking about, one, waiting until the vaccines obtain full FDA approval, and also waiting to see how this all works out in terms of how many people get their vaccines. In terms of incentives, my clients that have offered incentives have gone the way of a cash bonus or additional PTO. And I just wanted to underscore what Kendra just described. There are benefits and tax issues that come into play in these incentive programs, and there's some bells and whistles that you've got to put in place from a benefits perspective. So you should also be working with your benefits providers and your counsel when putting these programs in place. But in large part, there are some caps on the kinds of incentives that you can offer. And also, as Kendra has aptly described, for those folks who don't qualify for the incentive due to disability, et cetera, other types of options need to be offered.
Thanks to both of you for that insight. And Ann's comment that the vaccine has not been fully licensed by the FDA is an important one potentially that we haven't raised yet. The vaccine has been approved for under emergency use authorization. So it's been tested. You can do your research on the effectiveness of it, but it has not been fully licensed by the FDA. That doesn't change whether or not a private employer can require the vaccine or not, but it is impacting whether employers want to require it at this time because of, in part, the disclosure forms that people receive when they obtain the vaccine, which indicate that they have a right to object, a right to refuse the vaccine. And just because of the notion that it's not fully licensed yet. So that is a really important point, that we may see more companies move towards mandatory vaccines once it is fully licensed by the FDA. All right, I'm going to cover this very quickly because I want to make sure Ann has time to cover the reasonable accommodations piece. So please fire off questions if you have them. And then while Ann is giving her presentation on reasonable accommodation, Kendra and I will be looking through the questions and pulling out what we think we can answer in our time left. So in this, I'm going to touch briefly, and then we'll come back to it at the end if we have some time in the question and answer period. The big question that many employers have right now is, can we have different rules for unvaccinated employees? So we don't want to have a vaccine policy. We're not requiring it, but we encourage it. And we recognize that fully vaccinated employees are receiving more sort of latitude from the CDC, and that will continue with time. And so we want to loosen up the restrictions on them, or maybe even bring back vaccinated employees to the office and have unvaccinated employees work from home for a longer period of time. And employers are asking us, is that okay? Right now, in Minnesota, my answer to that would be no, it's not. And the reason is that we still have an executive order that requires the same face coverings, the same social distancing, the same hygiene requirements for vaccinated versus unvaccinated employees. There is no differentiation in the executive order. OSHA guidance, similarly, does not recommend different workplace safety initiatives or safety rules for vaccinated versus unvaccinated employees. So at this time, no. However, I don't want to leave it at that, because it seems like the direction we're trending is that some of those restrictions might be loosened up, and then employers will be faced with the option of deciding, do they want to have a different set of rules for vaccinated employees versus unvaccinated employees. As a general rule, if the restrictions are loosened, and if the CDC guidance and if the OSHA guidance allows for it, well, then yes, an employer could enact different sets of rules for vaccinated versus unvaccinated employees. But of course, the big question is, those agencies are talking about a health and safety perspective. They're not necessarily looking at it in terms of a discrimination perspective. So employers need to think beyond the CDC guidance on vaccinated versus unvaccinated employees and think about employment law considerations like discrimination. With respect to the people who choose not to be vaccinated, once we get to, say, the fall, the ones that have chosen not to be vaccinated, I'm willing to bet a large percentage of them have an exemption right. And so now you have a potential for a discrimination claim, either individual or on a class basis, if those individuals are subject to an entire different set of rules. Unless, of course, you can prove a business necessity for that. The other problem that we see with having a different set of rules for vaccinated versus unvaccinated employees is that it requires you to determine who is and who isn't vaccinated. I mean, in order to have the rules and enforce them, you either have to have employees voluntarily disclose and you simply accept their voluntary disclosure, or you have to ask for proof of vaccination so that you can enforce those different rules. Now, right now, the EEOC is saying on its website in a published guidance document that an employer can request proof of vaccination without violating the ADA. So the EEOC's position is that under the Americans with Disabilities Act, an employer can ask employees to prove their vaccination status. Many employers are taking that to mean, okay, well, we can start asking people whether or not they're vaccinated, and then we can decide what rules are going to apply. Our view of it is not so fast. Tap the brakes a little bit here. First of all, if you don't have a mandatory vaccine policy, if it's not required, if it's not a necessity of the job to have the vaccine, then why are you asking for proof? What is the purpose of asking for proof? Next, asking for proof is a very dangerous ground to be on if you don't have a vaccine policy, because it often leads to the disclosure of medical information. Simply asking whether or not someone is vaccinated is one thing. Asking for proof of vaccination often leads to disclosure or discussion of why someone is not vaccinated. And it can result in the employer receiving medical information from employees, and medical inquiries, whole different topic, but need to be done under the framework of rules that exist under both the ADA and also state anti-discrimination laws. Additionally, asking employees for proof of vaccination when you don't have a vaccination policy I would not base your decision solely on what the EEOC says on a website, because the EEOC does not necessarily, is not necessarily end all be all when it comes to discrimination laws. Most states have their own anti-discrimination laws. Some states even have their own laws about vaccines. So you need to be thinking about state law requirements, and before implementing any policy where employees are required to provide proof of vaccination, highly recommend that that is done with advice of employment counsel, because there are so many different things to consider. So it's being widely reported what the EEOC has said on their website. Take it for what it is and know that that's one layer, and there's about 7 other layers you have to peel back. So with that, I'm going to turn over to Ann to talk about reasonable accommodation since we're running out of time. My parting comments on vaccine initiatives and whether or not to have different rules for vaccinated versus unvaccinated employees is that really the discussion should start with what is our culture? What is our mission statement? What's our goal? The larger return to work goal. And where do vaccine initiatives and policies fit into that goal? How do we facilitate the ultimate goal with our vaccine policy? The vaccine policy shouldn't be the leader. It should be something that fits in to a much bigger picture, a bigger organizational goal. And I think you need to think carefully about, do we want to create 2 classes of employees? Those that have vaccinations and those that do not. Even if you can get through all of the legal exemptions and considerations, is that the culture you want? To have these 2 different groups of employees and have people need to identify as being Group A or Group B. These are really, this question, the answer won't be the same for every company, but those are really serious questions to consider. So with that, Ann, I'll pass it over to you. And Ann, take as much time as you need on reasonable accommodation, and Kendra and I will sift through questions.
Oh, sounds good. Thank you, Pam and Kendra, for your excellent comments. To round out our discussion this morning, let's focus for a few minutes on reasonable accommodation considerations and strategies in our new reimagined workplace that we're all talking about. We are in the midst of considerable change in the reasonable accommodation area. Not surprisingly, in light of Kendra and Pam's comments, we're faced with a delicate balancing act where there are considerable business needs and considerations. We've got employee shortages, patient demands, customer demands, supply delays, business expansion needs, particularly as the pandemic releases us a bit from its grip. But we're also in an environment, and it can't be emphasized enough, where employee expectations and sensitivities are heightened. Employees are expecting and seeking more, not less, flexibility in terms of how and when they perform work. And as employers, most of my clients are also telling me that recruiting and retention of talent in this competitive market are at top of mind. So employees are expecting and seeking increased flexibility when they need or feel they need to attend to personal or family matters, or where there's an illness or injury which requires their absence, or where they feel they need work accommodation in some other form. I'm just going to highlight a few of the current trends in the current legal environment because it is different than even several months ago. In addition to all of our the requirements that we're very, very familiar with under the Americans with Disabilities Act and the state and local human rights laws relating to reasonable accommodation, there are a number of other laws and orders that now come into play, and they're real, as Pam has emphasized. They have the force of law. There are various executive orders, a few of that have been referenced. And depending on where you are in the country, you need to be paying attention to those. An example is here in Minnesota. Another of Governor Walz's orders from May of 2020 is still in effect, and it addresses working conditions, accommodations of employees, and non-retaliation during peacetime emergency. it has, I think, been one of the many reasons why I have been seeing so many health and safety complaints within my clients, both formal clients' operations, both formal and informal, that come together with requests for reasonable accommodation. It's really kind of an interesting environment. But this May 2020 executive order directs that employers cannot retaliate or discriminate against someone for bringing health and safety concerns forward. It says that employees can refuse to work under conditions that they believe in good faith, raise serious physical harm type safety and health conditions, or of course death. And it also calls out that employees have the right to contact the State Department of Labor and Industry, and the DLI has the right to come into the workplace. Now, are these new requirements? Are these new rights? No, but the fact that the executive order has called it out means that it's at the front of the public's mind, it's at the front of employees' mind. The order also specifically calls out the employer's obligation to provide reasonable accommodation and indicates that the reasonable accommodation may include adjusting work schedules or work environment, allowing employees to continue to work from home, and allowing them to use leave. As Pam also referenced, OSHA in January of this year issued a new guidance on mitigating and preventing the spread of COVID in the workplace. The guidance document does specify that this does not constitute official OSHA standards or an OSHA regulation, but it also the document also repeatedly references the OSHA General Duty Clause, which requires employers to provide workers with a workplace free of recognized hazards that are causing or likely to cause, for instance, serious physical harm. As Pam mentioned, we expect that OSHA will issue actual standards in this area. The OSHA guidance from January also specifically calls out reasonable accommodation, which is kind of interesting. So even the agencies that are not really charged with enforcing reasonable accommodation standards and things of that nature are calling this out. And the OSHA guidance also talks about how important it is for employers to make sure employees know who to contact with questions or concerns regarding health and safety. I highlight these two examples, the OSHA guidance and the one executive order, to underscore that employees are seeing, I've seen it in many, many different situations, when they request a reasonable accommodation because of a health or a mental health issue, they're also very quick to bring up health and safety issues. So employers are finding they're having to go through a reasonable accommodation analysis and also follow up on what amounts to an internal complaint regarding health and safety. The EEOC, of course, has also issued a guidance, a very lengthy one, on the ADA and COVID, and we expect much more EEOC guidances to be issued as the new administration settles in. Other really, really important trends, Pam has touched on this. In the last 12 months, we have not seen a great deal of activity in terms of OSHA investigations, EEOC charges that relate specifically to COVID. But we do expect that there will be heightened enforcement in this area, and the agencies have said as much. And Pam has emphasized how much money, for instance, has been allocated to OSHA. We are going to see a very different OSHA, even in the next several months, I think. We have also seen in our own practices, even though there haven't been as many formal charges or litigation filed related to these issues, we are seeing an uptick in internal complaints regarding reasonable accommodation, the handling of reasonable accommodation, the denial of requests for leaves, the denial of reasonable accommodation, claims of retaliation, health and safety concerns, and we've seen an uptick in threatened litigation. employees have been very, very quick to involve counsel and to move towards threatened litigation. We also expect there will be a push on a federal and also on a state level, depending on where you are, for additional protections for employees. So in light of this, just very quickly, what are the recommended strategies for employers in the reasonable accommodation area? This is an absolutely excellent time while you're considering return to work issues and the direction the company will take with respect to vaccinations, to also examine the company's approach to reasonable accommodation decisions and the management of those decisions. What has been working for you? What has not been working for you? What are the levels of absences, and have you effectively managed those? Also, an audit of how good has your documentation been in this process? Do you have sufficient documentation to support decisions related to reasonable accommodation, and documentation to support that you've engaged in an interactive process? Those are critical when any legal claim is made. And where you don't have that documentation, the flip side is it's very difficult for us to do dance steps and defend those successfully for you. Another key thing to look at is how good has your communication been with the affected employees throughout the process? Another thing that you want to consider in this area is, what is the message you want to send to the employee population? Whatever process you follow, whatever policies you issue, sends a message not just to the employee that's affected by a request for reasonable accommodation, but to the employee at large, because we know employees talk to each other and about their experiences. Is the message we are sending one of handling reasonable accommodation in a fair and consistent manner? Is the message we're sending that we follow a fair process and we keep employees informed? Or are employees getting the impression that decisions are a bit arbitrary, communication is incomplete or delayed, or that people are treated differently in fairly similar situations? So what are our strategies and some of the components of a good process for navigating a reasonable accommodation decision? I'm just going to move through these very quickly given our time. You will want to tweak any policies and practices based on your review of past practices and documentation. As Pam had mentioned, even if you're not required to have a preparedness plan in place, it's a good idea to think about one, because the content of a preparedness plan and reasonable accommodation requirements go hand in hand. In any event, I think it's very important to develop some kind of framework for a process to be generally followed with reasonable accommodation decisions. In terms of the typical reasonable accommodation interactive process, communication and documentation is the key. Discussions with employees at the outset and throughout the process, following up with emails and memos to the employees about, what information is needed, when it's needed, getting back to them on your decisions when you've received information, for instance, from providers. Active communication throughout the process and documentation of that communication is key. It's also a good idea, if you haven't done so already, to develop some kinds of samples of communication and provider inquiries for this process so that you don't have to reinvent the wheel each time. And very, very critical to have designated individuals making these decisions. You've heard from Pam and Kendra how complicated these decisions are and how it can be, and how interwoven the business considerations and the safety protocols are with employee requests for accommodation. So reasonable accommodation comes into play at every turn these days. I'm going to jump into a couple of examples that will flesh out a bit how we would go about making reasonable accommodation decisions in this new environment. Pam's already discussed vaccines and the reasonable accommodation requirements that must be considered in the event an employer is going to make vaccines mandatory. I won't go into that, but let's take another example. You've got an employee who's worked remotely at the company since March of 2020 and actually worked with the company pre-COVID. The company's made a decision to encourage but not to require vaccines. And they are announcing, they're in an office environment, they're announcing a return to work as of September 1, 2021. In doing so, they've got the preparedness plan in place. They've covered all of the, dotted all the I's and crossed all the T's in that respect that Pam mentioned. But Mary, this employee that you have, contacts HR and says, I don't want to come back to work. I want to continue to work from home on an indefinite basis. Because I don't feel comfortable working in a work environment where people aren't vaccinated and you're not requiring vaccinations. What do you do? Well, you follow the process really that you've established for reasonable accommodation. It serves you well in many, many different circumstances. Meet with the employee and document for yourself the content and results of that meeting. Find out more about why Mary is concerned. Let's say that Mary confirms to you that there isn't a personal health or mental health issue that prompts her request. So you know then that the Americans with Disabilities Act and parallel state human rights laws aren't going to come into play. But Mary also starts raising concerns about health and safety, and particularly your health and safety protocols in the workplace. What are your next steps? Well, the individual has essentially raised a health and safety issue, which would key in the general duty clause under OSHA, depending on how she frames it. So what do? You obtain information on what her concerns are about those protocols. You document the decision, document the meeting. You work with counsel, frankly, to determine whether the questions that are being raised by Mary call into question in any way your preparedness plan if it's required, or your health and safety protocols. If adjustments need to be made, they should be made. And you document that process. You get back to Mary, meet with her, talk to her about what's been done, what the safety protocols are, and ultimately urge her to return to work. I'm fast forwarding this a little bit so that we'll have time for questions. If the decision ultimately is to terminate Mary's employment after giving her multiple opportunities to return, work with counsel to communicate that decision so that you've got good documentation of the reasons for the decision, your protocols, what you did with respect to her concerns that she raised, and that you followed a good faith process. Pam, I know you've been watching closely the case involving the Minnesota Teachers Union, which brings into focus some of the safety and health concerns and return to work concerns. Did you want to say a few words about that?
Sure, Ann, I can do that briefly here. So there was a high-profile case in Hennepin County. The Minneapolis Public School District had directed all Minneapolis teachers to return to work when they decided to go back to in-person learning, and the teachers union filed a lawsuit and moved for what's called a temporary restraining order, basically an injunction asking the court to order that the district not be allowed to call back employees who qualify for a accommodation to work from home in the past, and who had otherwise qualified for work from home under the executive order, which for schools was much broader than the ADA reasonable accommodations. The union was successful in their lawsuit. There was an injunction entered allowing anyone who had been given an accommodation in the past to continue the accommodation unless and until there was a specific determination as to that individual. So it's a really unique case that isn't directly maybe applicable to everyone tuned into this webinar, except one thing that really caught my eye. The reasoning that the judge used to enter the injunction, in part, was that these employees had been successfully performing their job remotely now for over a year. And so it's very difficult in that situation for an employer to say that it's not a reasonable accommodation, it's an undue hardship to continue this, because the district's view was being in person is an essential function of the job. And so therefore we must have them in person. But of course, the court looked at the history over the last year and the success over the last year of remote learning, and the fact, of course, that there was a good 40% of Minneapolis families who didn't intend to wanted to continue remote learning because that was an option. So a lot to be said about that case, but the punchline is this. If your employees have been working from home successfully for the last year and a month or year, that is something that unfortunately is going to cut against you if you deny employees the opportunity to continue working from home when they are entitled to a reasonable accommodation. Unless you have good documentation as to what wasn't working, why it wasn't successful, and what specific reasons there are that work from home arrangement cannot continue.
Thank you, Pam. That's an excellent segue into the next example that I have. As Pam mentioned, our experience over the last year and really over the last 6 months is that reasonable accommodation and what constitutes a reasonable accommodation has significantly changed, because employers made lots of accommodations over the last year just to keep the business going, just to keep the operation going. And these are all going to be thrown back in our faces by plaintiffs' attorneys when we claim that to provide a reasonable accommodation of remote work in a particular circumstance is an undue hardship. Let me just talk about an example that speaks to the issues that Pam raised that I actually had arise in part in one of my client situations. So let's say Sue is a call center worker and she's been working remotely since COVID began. The employer announces that everybody's going to come back to work on September 1. Let's assume all of the preparedness plan and all of that piece is in place. And Sue contacts the Human Resources Department and says, I don't want to come back to work. I need to work from home on an indefinite basis. She explains, and actually the employer is aware of this because she was given FMLA leave during that time, that she fell down the stairs, severely hurt her back. She had to have multiple surgeries, which essentially prevent her or severely limit her ability to be in a car or a bus or any form of transportation, which she would need to get to work. She also explains that she has trouble sitting and standing, et cetera, and the office environment's not conducive to that. Let's say the employer follows its process, meets with Sue, documents the meeting so that you've got that, explains to Sue the business reason why we're calling people, particularly in the call center, back, explains that we actually have monitored productivity of the call center employees during this COVID time, and the productivity is not meeting our business needs. Explains to Sue we need more information from your provider. This is going through the interactive process. And let's get back to this. And Sue brings back the information from her provider. These situations also always become more complicated than you originally imagined. And again, this is based on a real situation. So the provider comes back, confirms all of the health issues and restrictions that Sue has already shared with us, but also says that Sue's suffering from depression and anxiety due to the chronic pain, and she cannot be in an office environment due to the noise, the activity level, and just the general office environment. And the physician doesn't see a reasonable accommodation for this situation. Well, what do you do? In this situation, I would advise you to partner with counsel to work through this, but you go to the next steps. Okay, we've got the information from the provider, we've got the information from Sue, but we also have our significant business considerations, and we also have documented issues with performance of the call workers while we're working remotely. And in addition, in this circumstance, we had documented performance issues with Sue, both pre-COVID and during the remote work from home. So you get back with Sue, that's always the interactive process, explain the business considerations, the information, talk about the information received from the physician, ask Sue whether she's aware of any accommodation that might be made that would allow her to return to work, and she says no. So where do you go from there? You've got decent documentation of a business reason for this. Part of it is going to depend on what your level of risk tolerance is. You may decide to allow her to work remotely on a temporary basis and see if the performance issues turn around. They most likely will not, because they existed pre-COVID. And you could end up terminating for performance reasons and sort of skip the ADA issue entirely. But in the end, if your counsel, meaning me, might be comfortable taking this on, depending on advising you to go ahead with a termination, depending on your risk level. These cases are likely to be litigated, and we'll have more guidance in the months ahead. But there are strong arguments to be made, depending on the circumstances, that remote work will not always be a reasonable accommodation. I think we have a few minutes to move to Q&A, and we're going to do that. Kendra, do you have a few questions you wanted to answer?
Anne, actually, we wanted to throw one to you first, if that's okay, because it's related to your section. And just so everyone knows, we have a ton of questions. So I've been cranking through and answering as many as I can directly to individuals that were specific to them. We'll answer as many as we can live here. And then we will do our best to follow up. If you didn't get your question answered, one of us will follow up with you after the program. But Anne, I thought this is one you could cover. The question is, what if the employer does not require vaccines, but wants all employees to return to the office, and an employee says they're not comfortable returning unless and until everyone has been vaccinated?
Yeah, excellent question, and we are going to get this more and more. This is going to be a typical situation. What I would do, I'm always about framework and process, because you want, no matter what you end up doing in this situation, you want to have good documentation that you had a dialogue with the employee. So I would meet with the employee and flesh out, ask them open-ended questions, ask them what their concerns are, and in that, explain to them, because maybe they haven't read the preparedness plan, maybe they didn't listen during the training, explain to them all of the different safety protocols that are going to be in place to ensure the health and safety of employees. It's an educational moment. In that discussion, the employee is likely, because we've already had these, to raise health and safety issues, thinking that we haven't gone far enough in our protocols, or there's inconsistent application of those protocols. Be careful to listen for those, because you want to make sure that if somebody is raising health and safety concerns, that you look into those, get back to the employee with any changes that have been made or not made, because they're not required or not reasonable. But ultimately, if you are comfortable that you are in compliance with CDC, Department of Health, and the requirements of the preparedness plan, you get to move forward and require a return to work in this instance. The ADA does not come into play.
Thanks, Anne. I'm going to answer just a couple related questions. There's been 2 or 3 questions about this compensation issue that came up, distinguishing between remote workers and in-person work. And so Anne had very aptly recommended being extremely cautious about reducing pay for remote workers, because it can have discriminatory and disparate impact, specifically implications. So we received a couple follow-up questions along the lines of, say, parking benefits. Can we continue to, well, the question was pre-pandemic, parking was paid for downtown Minneapolis, and this company's trying to figure out how to handle parking in a return to the office 2 days a week. Can they offer a bonus for in-office attendance? Or are there other options? And I had wanted to mention this earlier, but a bonus, a commuting bonus or transportation bonus would be an excellent way, I think, to give some extra compensation to people that have those additional expenses because they're coming into the office, and you don't have to provide those to the remote employees. You would have a legitimate business reason for giving those bonuses to people who are coming into work, because the concept is it would cover transportation costs. So my answer to that, and if Ann or Kendra disagrees, feel free to jump in, is yes, that's a great way to provide some additional financial incentives for coming to the office without having two different pay scales, remote versus in the office. So everyone's paid the same, but if you regularly work in the office 2 days a week, you get a transportation bonus or a commuting bonus, whatever you want to call it, that it's tied to the additional expenses that are incurred when you have to come into an office. Similarly, go ahead, Ann.
I think that just on that point, I think that you might want to look into the tax treatment of that. I wouldn't call it a bonus. I would talk of it more in terms of expense reimbursement. Because if you're going to have a large remote workforce, but some people that because of their job responsibilities have to come into work, it's almost a refashioning of business expenses. So to reimburse them for their parking or their bus pass, and then there are benefits implications there. But yeah, in concept, absolutely, I wouldn't call it a bonus, and you'd want to coordinate to make sure that it's put in place correctly from a tax and benefits perspective.
Yeah, I agree with all those thoughts. I don't have anything more on that, but I've had several questions come in regarding the FFCRA, and so I'll take this time to address those. In short, and at a high level, the FFCRA has been extended on a voluntary basis for employers. So this is a way, actually, I think, to provide some of the flexibility to employees at least through the end of September, again, on a voluntary basis, but allow you as an employer, if you're covered under the FFCRA, to claim some tax relief as a result. And at a high level, what the American Rescue Plan did for the FFCRA was, again, extend it on a voluntary basis. So employers, starting today, actually, because there was a period at the end of 2020 when the whatever relief package got passed in December 2020 extended the FFCRA on a voluntary basis so employers could choose to offer it and get some tax relief, but didn't have to. The relief package at the end of 2020 allowed employers to offer that on a voluntary basis through the end of March. We are now at April 1. The American Rescue Plan extended the option for employers to offer FFCRA leave on a voluntary basis through the end of September. Again, voluntary, don't have to do it, but if you offer it, you get some tax relief. The American Rescue Plan also refilled the bucket of emergency paid sick leave for employees. So that is the 10-day or the 2-week bucket of leave under the FFCRA. If employees previously exhausted that, they could now have an additional 10 days. There's some debate right now about whether it's 10 days or 80 hours of new leave to use if employers choose to extend that option. What the American Rescue Plan also did was expand the reasons for FFCRA leave if employers choose to offer it on a voluntary basis. Most namely, it now includes time off for vaccination, either to get the vaccination or to recover from side effects. So I actually think it's a great way for employers who choose to extend the leave to offer that kind of PTO and flexibility that we've been talking about to get the vaccination, but while receiving some tax relief and tax benefit. So again, highlights are voluntary, but you can get some tax relief for it. And I don't know, Karin, if the resources that get sent out include our question of the day, but I recently wrote a question of the day article on this issue, and I would encourage folks who have questions about the American Rescue Plan to check that out, because it may answer some of the other questions that you have.
Thank you, Kendra and Pam, and thank you to all of our attendees. We're going to wrap up because I want to be respectful of attendees' schedules. We will receive a printout of all of your questions, and we will endeavor to respond to those by email. We look forward to seeing you in future seminars, future webinars, and also in our annual seminar in the fall. We hope you have a good rest of your week, and we look forward to meeting with you, working with you over the next months. And also, when we get beyond this COVID craziness, to seeing you in person again. Thank you. Enjoy the rest of your day.
Thanks, everybody.